Look at this security tape. Grainy. Black and white. A shopping center on an ordinary Friday afternoon. The kind of place you have walked through 100 times without remembering a single detail about it. A toddler in a blue coat, walking hand in hand with a bigger boy. To everyone in that mall, it looked like nothing. A big brother minding his little brother while their mum finished up at the till. A few people even smiled at it. Nobody stopped it. Nobody thought for even a second that they needed to. That toddler was 2 years old. His name was James Bulger. And the boy holding his hand was not his brother. He was 10 years old. And in a few hours, James would be dead. There were two of them actually. Two 10-year-old boys, so ordinary looking that a security guard, watching them in real time on the store monitors, did not think twice. Kids look after kids. That is what the tape looked like. That is what everyone who saw them that day believed, right up until they did not. They led him 2.5 miles across the city. Past busy roads. Past dozens of adults going about their afternoon. Later, investigators would establish that at least 38 separate people saw the three of them together that day, a small crying toddler and two older boys, and not one of them stepped in. That is not a story about a monster lurking somewhere in the shadows, waiting. That is a story about horror walking in broad daylight, past 38 sets of eyes, and somehow, none of them seeing it for what it was. What happened to James Bulger that afternoon is one of the most shocking crimes committed in Britain in the last century. I'm not going to describe every detail of it. You do not need the details to understand the weight of it, and frankly, some of it does not need to be repeated. What you need to understand is that when the officers investigating this case were shown the scene, hardened detectives who had spent careers looking at the worst things people do to each other, some of them had to leave the room. His body was found 2 days later on a railway line, left there deliberately, arranged to make his death look like an accident. The nation did not just grieve. It fractured. Because the question that followed was not who did this. Police found that out disturbingly fast. The question that followed was one nobody had a good answer for, and in some ways still does not. How do you make sense of two children doing this to another child? Not strangers. Not monsters from a horror film. 10-year-old boys, the same age as the kid 3 doors down from you, the same age as the quiet one at the back of a primary school classroom. This is the story of Robert Thompson and John Venables. It is the story of a 2-year-old boy named James. And it is the story of a country that, more than 30 years later, still has not fully agreed on what any of it means. Before we go further into this one, if you are new here, this is Criminalia Cases. We dig into the cases that do not just shock you for 5 minutes and disappear, the ones that actually changed how a country thinks about justice, childhood, and what it means for something to go permanently, catastrophically wrong. If that is the kind of story you are here for, hit subscribe and drop a like on this video before you keep watching. It genuinely helps us keep making deep, well-researched cases like this one instead of the fast, shallow stuff. Turn on notifications too, because we have got more of these coming. Alright. Let us get into it. What followed has become one of the most examined 2.5-mile walks in British criminal history. Robert Thompson and John Venables, though at the time nobody watching them knew their names, walked James Bulger across Bootle and into Walton, a journey that took roughly 3 hours. They did not move quickly or furtively. They stopped. They wandered. At points, James cried and was seen crying by people who noticed and did nothing more than notice. In the investigation that followed, police identified 38 separate witnesses who recalled seeing the three boys together that afternoon. The tabloids would later nickname this group the Liverpool 38, a shorthand that captured something the entire country was struggling with. How does a toddler get walked across a city, visibly distressed, past 36 adults, without a single one of them intervening? It is worth sitting with that question rather than rushing past it, because the answer is not really about 38 uniquely careless people. It is about how thoroughly the presence of two older children normalized what should have looked alarming. A few witnesses later said they assumed the boys were James's brothers. One recalled the older boy handling him roughly and thought about saying something, and did not. Not out of cruelty. Out of the very ordinary, very human instinct not to interfere in what looks like somebody else's family business. That instinct, the one that tells us not to make a scene, not to embarrass ourselves by overreacting to what is probably nothing, became one of the most painful footnotes of the entire case. Because it was not nothing. Along the route, according to later reconstructions, James was hurt more than once, dropped in one case hard enough that a mark was later visible. He was crying, sometimes audibly, as they moved through residential streets and past a canal. Along the way, the boys stopped at several locations that would later become significant in the investigation. A canal bank, a busy road they walked James across without checking for traffic, a stretch near a pet shop. Some witnesses recalled the older boy walking James roughly, tugging him along faster than his small legs could comfortably manage. A few remembered him crying. One recalled thinking the interaction looked odd enough to make a mental note of it, and then continuing on with their day regardless. This is the detail that, more than any other, seems to haunt people who study this case closely. The walk was not fast and it was not hidden. It happened across open streets, past shop fronts, alongside a canal where dog walkers were out, near a main road at a time of day when foot traffic was steady. There was no single dramatic moment where an alert adult could point and say that is clearly wrong. Instead, there were dozens of small moments, each one ambiguous enough on its own to explain away, and the ambiguity of each one is exactly what let all 38 of them pass without incident. Eventually, the boys reached a stretch of railway line in Walton, roughly 3 hours after they had first approached James outside the butcher's shop. What happened there is the part of this story that I am choosing not to narrate in detail. It has been documented exhaustively elsewhere, in trial transcripts, in books, in decades of press coverage, and none of that documentation makes it easier to hear or more meaningful to repeat. What matters for understanding the case is this. James Bulger was killed with a level of violence that, when it was later read out in court, visibly affected people who deal professionally with violent crime for a living. His body was left on the railway line, and it is believed the boys intended for a train to strike it, to disguise what had happened as a tragic accident rather than a murder. For 2 days, James Bulger's disappearance was a missing child case, not yet understood as a murder investigation. Denise and her husband Ralph made public appeals. The story was already spreading through local and then national news. A toddler vanished from a shopping center, taken seemingly right out from under his mother's attention in the space of a few paying at the till minutes. It was the kind of story that grips a country immediately, because it taps into a fear nearly every parent recognizes. The several-second lapse that becomes irreversible. Then, on the 14th of February, 2 days after he vanished, James Bulger's body was found on the railway line in Walton, not far, as it turned out, from a police station. He had been struck by a train after being left on the tracks, though a subsequent post-mortem examination determined he had already died from his injuries before that happened. The country's fear shifted, instantly and permanently, from who took him to something far harder to process. Investigators initially worked from an assumption that is almost reflexive in child abduction cases, that an adult was responsible. It is the shape true crime followed for decades before this case and for decades after. A predatory adult, a stranger, sometimes someone known to the family. That assumption did not survive contact with the CCTV footage. When detectives reviewed the shopping center tapes, what they found upended the entire framework of the investigation. The person who led James Bulger away was not an adult. It was 2 children. The footage was released to the public in the hope that someone would recognize the boys. It worked with unnerving speed. Multiple people came forward, including, according to later reporting, an anonymous tip that pointed investigators toward 2 specific 10-year-old boys who had been absent from school on the day James disappeared, and who lived locally. Robert Thompson and John Venables were arrested on the 18th of February, 1993, 6 days after James disappeared. Arresting 2 10-year-old boys for murder created legal and procedural complications that Merseyside police had essentially no precedent for. Interviewing child suspects in a case of this magnitude required appropriate adults present throughout, typically a parent or guardian alongside legal representation, and investigators had to navigate all of this while also managing an investigation moving at extraordinary speed, under an unprecedented level of national media attention. Detectives worked to corroborate the CCTV footage against physical evidence. Paint transfer and other forensic traces recovered from clothing were compared against the railway line and surrounding scene. Both boys' homes were searched. Both boys' school attendance records were checked and confirmed they had been absent on the day in question, a detail that had already drawn suspicion from the anonymous tip that first pointed investigators toward them. During initial questioning, both boys denied involvement. Over the following days, as investigators presented each of them separately with the CCTV stills and mounting evidence, their accounts began to shift, and as is common in cases involving multiple suspects, each began attempting to minimize his own role while emphasizing the others. It is worth noting, because it speaks to just how unusual this case was procedurally, that the interview tapes from these sessions were later played in part during the trial itself, meaning a jury sat and listened to two 10-year-olds, recorded during police questioning, describing what had happened to a toddler in fragmented, sometimes contradictory, unmistakably childish language. Reporters covering the trial described it as one of the most difficult pieces of evidence anyone in the courtroom had to sit through, precisely because of how young the voices on the tape sounded. By the 20th of February, both boys had been formally charged with abduction and murder. British law protects the identities of child suspects, so for months, the two boys were known to the public only as Boy A and Boy B. A legal anonymity that, in hindsight, only deepened the sense of dread around the case. The country knew children had done this. It just did not know which children or what they looked like, or how two ordinary 10-year-olds from ordinary streets had ended up here. During questioning, each boy reportedly attempted to shift blame toward the other. This is, in itself, unremarkable. It is a nearly universal instinct under interrogation for children and adults alike. What made it harder to process here was the age of the two people doing it. Interview tapes and later court testimony painted a picture of two children who understood at some level that what they had done was wrong, and who were now trying to survive the consequences the only way they knew how, by pointing at each other. Forensic evidence, along with the boys' own shifting accounts, eventually built a case strong enough to charge them both with abduction and murder. The trial began in November 1993 at Preston Crown Court, moved from Liverpool partly due to the intensity of local publicity. It is worth pausing on the sheer strangeness of what that trial looked like. Robert Thompson and John Venables, both 10 years old at the time of the killing and 11 by the time of the trial, sat in a specially constructed raised dock so they could see over the barristers' benches, because they were too small to see the proceedings from a standard adult dock. They were tried as adults in an adult Crown Court, under the full formal weight of the British legal system, in front of a jury, a judge, and a public gallery that, according to contemporary reporting, was openly hostile. For 17 days, the court heard evidence most adults would find difficult to sit through. Journalists covering the trial later described jurors visibly shaken by aspects of the testimony. This was, by any measure, one of the most disturbing trials in modern British legal history, not just because of what had happened to James Bulger, but because of who was sitting in the dock for it. The formality of it all is what tends to strike people most when they read accounts of the proceedings now. Barristers in wigs and gowns. A judge presiding with the same procedural weight he would have brought to any adult murder trial. Legal arguments over admissibility of evidence, conducted in the same dense courtroom language used in any Crown Court case, while two 11-year-olds sat and, by multiple accounts, sometimes seemed to lose track of what was being discussed entirely, occasionally fidgeting, occasionally appearing to daydream, the way children that age do in any setting that goes on too long and involves too many words they do not fully understand. That contrast, adult procedure applied to a child's attention span, became one of the central pieces of evidence in the European court challenge that would come years later, arguing the boys could not meaningfully participate in their own defense in an environment built entirely around adult comprehension and adult composure. Outside the court, the atmosphere was very different. Crowds gathered daily. Some held signs. Tabloid coverage during the trial was extensive and unrelenting, with front pages devoted to the case day after day for the full 3 weeks of proceedings. Public anger, which had been building since James's disappearance became national news, found its focus once Thompson and Venables were identified as suspects. Even before formal reporting restrictions were lifted, their identities had begun circulating locally, and by the time the verdict came down, there was little appetite left in the country for anything but the harshest possible outcome. On the 24th of November, 1993, the jury returned its verdict after a matter of hours, guilty on charges of abduction and murder. Presiding Judge Mr. Justice Moreland described what Thompson and Venables had done as an act of unparalleled evil and barbarity. He sentenced them to be detained at Her Majesty's pleasure, the formal term for an indefinite juvenile sentence, with an initial minimum term of 8 years before parole could even be considered. Robert Thompson and John Venables became the youngest people convicted of murder in England in the 20th century. This is the part of the story that offers no comfortable answers, and I want to be upfront about that before we go further. because it would be easy and dishonest to pretend that a tidy explanation exists. Robert Thompson was born in August 1982, the fifth of 7 children in a Liverpool family. Reporting from the time and since has described a genuinely chaotic home environment. A father who was, according to multiple accounts, violent, and a mother who struggled significantly, including with alcohol, while raising a large family largely on her own after he left. Thompson's later parole statements referenced a childhood he described as troubled, and he told the parole board that at the time of the murder, his home life had left him, in his words, out of control. John Venables came from what has generally been described as a more conventional home, though not without its own difficulties. His parents separated when he was young, and accounts from teachers and neighbors described him as a child prone to sudden aggression, occasionally bullied himself and at other times a bully toward younger or smaller children. He struggled academically and had been receiving additional educational support in the period before the murder. Neither boy had a documented history that, on its own, would have led anyone to predict what they would do together. That is part of what made, and still makes, this case so difficult for criminologists, psychologists, and honestly ordinary people trying to understand it. When the two of them were evaluated separately by psychiatrists during the legal process, the conclusion reached was not that either boy suffered from a diagnosable mental illness or a clear developmental abnormality. They were found to understand at the time of the killing that what they were doing was wrong. That finding is, in a strange way, more unsettling than a tidy diagnosis would have been. A verifiable illness gives an audience somewhere to put its fear. An explanation, a category, a reason this does not apply to other children, other families, other ordinary Tuesday afternoons. What this case offered instead was 2 boys who reportedly understood right from wrong, who came from difficult but not wildly unusual home circumstances, and who did something that the collective imagination of an entire country still struggles to place anywhere. There has been extensive academic writing since 1993 debating exactly this question. Nature versus environment, the specific compounding effect of neglect and exposure to violence in Thompson's case, the role that a friendship dynamic between 2 particular boys might have played in escalating behavior that either might never have engaged in alone. None of it produces a single, satisfying answer. Much of the serious scholarship on the case explicitly concludes that no single answer exists. One thread that does recur across multiple academic treatments of the case is the idea that this was, in some fundamental way, a 2-person phenomenon rather than something either boy would necessarily have been capable of individually. Thompson has often been described, in psychological assessments and later commentary, as the more dominant of the 2, colder under pressure, more capable of composure during questioning. Venables has been described as more visibly emotional, more prone to breaking down. Some researchers have theorized a kind of mutual escalation dynamic, where each boy's presence and apparent willingness pushed the other further than either might have gone alone. A pattern that shows up, in less extreme forms, in other cases of group violence among children and teenagers, where individual restraint erodes specifically because of the audience of a peer. This does not function as an excuse, and serious researchers examining the case have generally been careful not to present it as one. It functions instead as one piece of a much larger, still unresolved puzzle about how ordinary childhood friendship dynamics can, in rare and devastating circumstances, become something else entirely. There is a legal detail buried inside this case that rarely gets attention outside academic circles, and it is worth pulling out here because it explains a lot about why this case became such a lightning rod. In England and Wales, the age of criminal responsibility, the age at which the law considers a child capable of forming criminal intent and being held fully responsible for it, is 10 years old. It was 10 in 1993 and remarkably, it remains 10 today, making it one of the lowest ages of criminal responsibility anywhere in Europe. For comparison, in much of continental Europe, the threshold sits at 14. In Scotland, it was raised to 12 in 2019. In several Scandinavian countries, it is 15. This meant that when Thompson and Venables were arrested, there was no legal question about whether they could be charged with murder at all. The only real legal debate was over whether it was appropriate to try 2 10-year-olds using the exact same adult Crown Court procedure used for a 40-year-old defendant, with the same rules of evidence, the same courtroom formality, the same expectation that a defendant could meaningfully track and participate in their own trial. Britain's answer in 1993 was yes. It took nearly a decade and a ruling from an international human rights court before that answer was formally revisited. This detail matters because it is part of why the case became such a persistent reference point in legal and academic writing. It sits directly at the intersection of two questions that do not have clean answers. At what age is a child capable of truly understanding the finality of taking a life? And once that line has been crossed, what does a justice system that still calls itself a justice system, rather than pure punishment, actually owe a child defendant? If the crime itself shocked Britain, the aftermath revealed just how deep that shock ran and how far it would travel into the country's politics, media, and legal system. Tabloid coverage of the trial and its aftermath was, by any measure, ferocious. Headlines called for the boys to be named, shamed, and punished as harshly as the law would allow. Public anger was not confined to newspaper front pages. Protesters gathered outside the courthouse during the trial, and in the years that followed, there were repeated attempts by members of the public to track down and confront the two boys, both during their incarceration and after their eventual release. That fury reached directly into government policy. Shortly after sentencing, the presiding judge's initial 8-year tariff was increased to 10 years by the Lord Chief Justice. Then, in a decision that would trigger years of legal battles, the Home Secretary at the time, Michael Howard, personally intervened and raised the minimum tariff again to 15 years, citing in part public petitions and tens of thousands of letters demanding harsher punishment. It is difficult to overstate how unusual this was. A government minister responding directly to public and media pressure, overriding a judicial sentencing decision for two children. Some tabloid campaigns at the time explicitly petitioned for the harshest sentence the law would permit, framing the 15-year tariff push as giving the public a direct say in how long two child killers should spend behind bars. Howard's office received tens of thousands of coupons, letters, and petition signatures in the weeks following sentencing, an outpouring that, whatever one thinks of the underlying policy question, represented one of the largest public campaigns around a single criminal sentence in modern British history. It set off a legal fight that would occupy British and European courts for the better part of a decade. Thompson and Venables' legal teams challenged Howard's intervention, arguing it was politically motivated rather than judicially reasoned. In 2002, roughly 6 years after the case had first been raised, the House of Lords ruled that Howard had acted unlawfully in setting the tariff the way he did. Then, at the European Court of Human Rights, judges went further, ruling that trying two 10-year-old children in a full adult Crown Court, with all its formality, its raised docks, its adult procedures, and its intense public and media scrutiny, had violated the boys' right to a fair trial. The ruling did not overturn their convictions. But it did force Britain to fundamentally reconsider how it handles child defendants, and it remains one of the most cited cases in debates over juvenile justice reform in the UK to this day. Politically, the Bulger case became something closer to a national reckoning point. It arrived at a moment when British politics was already shifting toward tougher rhetoric on crime, and the case became something both major parties invoked, in different ways, to justify harder lines on youth offending. It is referenced, still, in academic and journalistic writing as one of the defining moments that reshaped how Britain talks about children who commit serious crimes, not softening that conversation but hardening it permanently. Robert Thompson and John Venables were released from custody in June 2001, having served 8 years, the original tariff set at trial, restored after the legal challenges to Howard's 15-year intervention succeeded. Both were given new identities and a worldwide court injunction guaranteeing them lifelong anonymity. A legal protection almost unprecedented in scope, covering not just their names but any information that could be used to identify or locate them, indefinitely for the rest of their lives. The reasoning behind the injunction was straightforward and, frankly, well-founded. Given the sheer intensity of public anger toward them, authorities genuinely believed that if their new identities became known, their lives would be at serious risk from vigilante violence. For a period after release, relatively little was publicly known about how either man was living. Thompson, in particular, has rarely surfaced in public reporting since 2001. Venables' post-release story has been very different. In a parole statement from 2001, later revealed publicly through a documentary years afterward, Thompson described feeling ashamed of what he had done and said he had become, in his own words, a better person as a result of his years in custody, while acknowledging the strange irony embedded in that statement. Ralph Bulger, James's father, publicly rejected the sincerity of that apology, saying he would never accept remorse from either of the two men responsible for his son's death. Chapter 8. Venables. If Thompson's post-release life became, by design, almost entirely invisible to the public, John Venables did not, though not by his own choice and not for reasons that reflect well on him. In 2008, Venables was arrested following a drunken altercation and received a formal warning for breaching the terms of his release license. Later that same year, he was cautioned for cocaine possession. Then, in February 2010, Venables was recalled to prison after indecent images of children were discovered on his computer. He was later charged and convicted on those charges. He was released again in 2013 and recalled once more in November 2017, after being found in possession of similar material a second time, resulting in an additional prison sentence. Venables has since faced multiple parole hearings, reviewed in 2020 and again in more recent years, with the parole board on at least one occasion explicitly citing ongoing risk to children as grounds for continued detention. Each time his case has come up for parole, it has reignited the same public and political debate that has surrounded this case since 1993. Whether rehabilitation genuinely occurred. Whether it is possible to fully rehabilitate a child who commits an act of this severity. And whether the system that released him in 2001 believing he had been rehabilitated was, in hindsight, simply wrong. In 2024, more than 200,000 people signed a petition calling for a full public inquiry into how Venables' case had been handled, prompting a parliamentary debate. Members of Parliament argued that the Bulger family deserved more transparency about why Venables had been assessed as safe for release in 2001, given what came after. One MP, addressing the debate directly, argued that if there was truly nothing concerning in how the case had been managed, the government should simply lay out the facts rather than continue resisting scrutiny. The government's position at the time that debate took place was that a full public inquiry was not necessary. Each parole hearing since has followed a familiar, painful pattern. Closed-door proceedings that the Bulger family is not permitted to attend in person, though their written victim impact statements are read into the record and considered by the board. A wait of roughly 2 weeks for a decision. And when the outcome becomes public, a fresh wave of national news coverage that forces the entire case back into the spotlight, whether the family is ready for that or not. Denise Fergus has described, in interviews given around these hearings, the toll of having to essentially relive the case's aftermath on a recurring, unpredictable schedule dictated by someone else's parole eligibility. As of the most recent public reporting, Venables remains in custody, with the parole board having repeatedly concluded that he continues to present a risk, particularly to children. It would be a disservice to this story to let it become only about the two boys who killed James Bulger, because that is, in a very real sense, exactly the dynamic his family has spent more than 3 decades fighting against. Denise Fergus, James's mother, has remained a public and outspoken figure since 1993, campaigning consistently for victims' rights and for greater transparency in how the justice system handles cases like her son's. In 2011, the year James would have turned 21, she established the James Bulger Memorial Trust, a charity supporting young people who are victims of crime, hatred, or bullying, turning what happened to her son into an organization intended to protect other children going forward. Ralph Bulger, James's father, has also remained a public presence, particularly whenever Venables' case returns to the headlines around parole hearings, consistently rejecting any suggestion that either man's remorse should be taken as sincere or sufficient. Denise, in particular, has described the experience of the last 3 decades as one where grief never gets the chance to fully settle, because the case simply refuses to stay in the past. Every parole hearing, every documentary, every anniversary news cycle reopens it publicly, on a schedule she does not control and cannot opt out of. She has spoken, in various interviews over the years, about the exhaustion of having to relive her son's death in the public eye essentially on demand, whenever Venables' name resurfaces, while also feeling a responsibility to keep showing up and keep speaking, precisely because she worries what might happen to public accountability if she stopped. That tension between wanting to move forward and feeling obligated to keep fighting, is one that runs through nearly everything she has said publicly since 1993. It is also, honestly, a dynamic that a lot of families of high-profile crime victims describe. Once a case becomes this deeply embedded in a country's collective memory, the family stops being able to grieve privately because the case has, in a sense, stopped belonging only to them. Denise's and Ralph's marriage did not survive what happened. This is, sadly, an extremely common outcome for parents who lose a child to violence. The strain of grief, of public scrutiny, of an entire nation treating your private tragedy as a national case study, tends to be more than most relationships can bear. Denise later remarried and had 2 more sons. Ralph also remarried and had children. James Bulger would be in his mid-30s now, had he lived. He remains, more than 3 decades on, one of the most referenced victims in British criminal history, not because of anything he did, but purely because of what was done to him, at an age when he was too young to understand any of it. Chapter 9.5. A name that became a reference point. In the years since 1993, this case has become something larger than itself in British public life. A kind of shorthand that journalists, politicians, and academics reach for whenever a new case involving extreme youth violence emerges. Commentators and researchers have, at various points, drawn direct comparisons between this case and other instances of child-on-child violence in different countries, cases in the United States, in Norway, and Japan, not because the details are similar, but because each one reignites the same unresolved public argument. Is a child capable of a level of premeditated cruelty typically associated with adult offenders? And if so, what obligation does society have to that child afterward, versus its obligation to protect itself from him? The phrase the Bulger effect has been used informally in British media and political commentary to describe the broader hardening of public and political attitudes toward youth crime that followed this case. A shift toward harsher sentencing rhetoric, increased skepticism toward rehabilitation-focused juvenile justice models, and a media environment considerably more willing to name, photograph, and permanently brand child offenders than it had been before 1993. Multiple television documentaries have been made about the case in the decades since, along with academic books examining it from criminological, psychological, and legal perspectives. It remains to this day one of the most written about criminal cases in British history, not primarily because of the crime's method, which, however horrific, is not statistically unique in the broader history of child homicide, but because of everything that followed it. The trial, the tariff battles, the European court ruling, and the recurring public reckoning every time one of Venable's parole hearings makes headlines again. It is difficult to identify another single case in modern British history that reshaped as many different institutions as this one did. It changed how the country legally handles children accused of serious crimes, eventually contributing to reforms in how child defendants are tried, following the European court's ruling that the original Crown Court trial had violated the boy's right to a fair hearing. It changed the relationship between the Home Office and judicial sentencing, after the House of Lords ruled that a government minister could not simply override a court's sentencing decision because of public pressure. It became a fixed reference point in academic criminology, cited constantly in research on juvenile violence, on the psychological effects of exposure to domestic abuse and neglect, and on the limits of what any evaluation, however thorough, can actually predict about future behavior. It also changed the media landscape around crimes involving children, in ways that are still being debated. The sheer scale and intensity of the public reaction, the protests outside the courthouse, the campaign for harsher sentencing, the repeated vigilante attempts to identify Thompson and Venables after their release, the parliamentary debates that continue to this day, raised uncomfortable, unresolved questions about where public accountability ends and something closer to mob justice begins. Questions that Britain still has not fully answered. And it left behind an uncomfortable, unresolved core question that no court ruling, no parole hearing, and no piece of academic research has definitively settled. What do you do with two children who commit an act of adult-level violence? Punish them as adults, and you are applying a legal framework built around concepts of culpability and intent to minds that were, by every developmental measure, still children. Treat them purely as children in need of rehabilitation, and you risk minimizing the scale of what was actually done, and the lifelong grief of a family that will never get their son back. Britain, in the years since 1993, has tried both approaches in sequence, under enormous public pressure each time, and neither has produced anything close to consensus even now. There is no comfortable way to end this one, and I am not going to pretend there is. James Bulger was 2 years old. He liked, by every account from people who knew him, ordinary things, the things every toddler likes. He had a mother who was paying for groceries and looked away for a matter of seconds, the way every parent of a toddler does, dozens of times a day, almost always without consequence. Robert Thompson and John Venables were 10 years old. They came from imperfect but not extraordinary homes. They understood, by every professional assessment made of them at the time, that what they were doing was wrong while they did it. More than 30 years later, one of them has spent much of his adult life back behind bars for offenses against children. The other has, by design, vanished entirely from public view, his current life unknown even to the family of the boy he killed. And somewhere in the middle of all of that is a 2-year-old in a blue coat, walking hand in hand with someone who was never his brother, past 38 people who assumed, reasonably, that nothing was wrong. That is the story. There is no tidy lesson at the end of it. Just a boy who should have grown up, and a country that, decades later, still has not agreed on what it should have learned from the fact that he did not. If this case affected you the way it affected us putting it together, Let us know in the comments. And if you want more deep dive cases like this one, subscribe to Criminalia Cases. We have got more coming.